When a dispute arises, there are a variety of ways in which we can resolve that dispute. Mediation is one of them. The purpose of today's video is to get a better understanding of what mediation is. So we're going to define mediation, and then I'm going to contrast it with other ways of resolving disputes so that we get a better understanding of how mediation is different from, for instance, going to court or going to arbitration. One way of defining mediation has been given by Professors Haupt and Stefik, who have conducted extensive comparative research to develop the following definition. They define mediation as a procedure based on the voluntary participation of the parties in which an intermediary with no adjudicating powers systematically facilitates communication between the parties with the aim of enabling the parties themselves to take responsibility for resolving their disputes. So if we take a closer look at this definition, we see that there are 4 core elements to mediation that distinguish it from other methods of dispute resolution. The first one is voluntariness. And this is essentially the cornerstone of mediation. Without the voluntary participation of the parties to mediation, it is unlikely that mediation will end up being successful. If one of the parties is coerced into mediation, then it's unlikely that they will be able to effectively collaborate with each other to resolve the problems that are underlying the dispute. So the voluntary participation of both parties to mediation is essential. The second element that we find in the definition provided by Professors Haupt and Stefik is that the parties take responsibility for resolving the dispute. Now we can distinguish 2 different aspects to the parties taking responsibility. In the first place, they have control over the process in the sense that they determine what the procedure is going to look like. They determine how the mediation is going to be conducted. They also control who can be chosen who they choose to be the mediator. And they can also decide whether they do this on an ad hoc basis just between them, or whether they go to an institution that offers mediation services and follow the procedure that is laid out by that mediation service. Parties taking responsibility has another aspect to it, and that is that they have responsibility for the outcome. It's the parties who control the result of mediation. And that means that they are in charge of deciding whether it's going to be successful, for instance, that there is a settlement agreement that arises from the mediation, or whether mediation ends up being unsuccessful and they walk away from the proceedings. Perhaps that means they have to go and take it a step further, go to litigation, for instance, but that is all within their control and their responsibility. When it comes to the parties' control over the outcome of mediation, this is where we need to take a look at the role of the mediator. It's important to note that the mediator is there as a facilitator of the process and not as a decision maker. So a mediator has no decision-making authority within the mediation proceedings. It's not the mediator who is going to decide what the outcome of the dispute is. It's not the mediator who determines the content of the settlement agreement. The mediator is there essentially to enhance the negotiation proceedings, to facilitate the communication between the parties, and to help them bring out onto the table the interests, the values, the problems that have essentially led to the dispute that the parties are having. A third element that we see in the definition provided by Haupt and Stefik is that mediation is essentially a problem-solving mechanism. And we will get into this a little bit later in the video when I contrast this with adjudicatory proceedings. But mediation is about solving the problem that underlines the dispute between the parties. And that means that the parties who are participating in mediation have the freedom to create what Professor Nolan Haley has referred to as individualized justice. So they can create their own solutions that answer the issues and the problems that has arisen between them. They are not constricted by precedent or by law in the way in which they resolve their dispute. They are capable of coming up with unique and creative solutions in order to resolve the problem that they have encountered between them. The fourth element of mediation, and it doesn't come directly from the definition I just gave you, but it is a core element of mediation, and that is confidentiality. It underlies many of or the three other elements that we've just discussed: voluntariness, control over the process and the outcome, and the problem-solving mechanism. Mediation requires the parties to collaborate together, to cooperate with each other, to create a solution to the problem that has arisen between them. In order to do that, they need to be able to discuss freely and openly with each other what their interests are, what is underlying the dispute, what underlies the positions that they are bringing to the table, in order to be able to dig deeper and come with an effective solution. In order to be able to do that, they need to be assured that there is confidentiality, that what they tell each other during mediation, that's not going to be used against them subsequently in litigation. So the confidentiality regime within mediation is essential to support the effectiveness of the mechanism itself. So now that we've defined mediation and looked at its core elements, let's contrast it with other dispute resolution mechanisms to see how it differs and what unique possibilities mediation offers in contrast to, for instance, going to court. In order to do that, I would like to introduce you to a dispute resolution continuum. On the continuum, we see two elements. On the top, we see a spectrum that goes from consensual dispute resolution mechanisms to adjudicative dispute resolution mechanisms. On the bottom, there is a spectrum that goes from informal dispute resolution mechanisms to formal dispute resolution mechanisms. The top spectrum relating to consensual versus adjudicative dispute resolution mechanisms relates to who is in charge of deciding the outcome. So who decides the way in which the dispute is going to be resolved? On the left-hand side of the spectrum, where we're talking about consensual dispute resolution mechanisms, it's the parties themselves that are involved. They determine the outcome of the dispute. On the right-hand side of the spectrum, the adjudicative dispute resolution mechanisms, the parties cede control over determining the outcome of their dispute to a neutral third party. So it's the neutral third party who decides the outcome of the dispute between the parties. The spectrum on the bottom, leading from informal to formal dispute resolution mechanisms, relates to the nature of the procedure. How much control do the parties actually have over the way in which the dispute is going to be resolved? The informal dispute resolution mechanisms, it's the parties who determine how the proceedings will take place, whether or not they intend to to participate in those proceedings. On the right-hand side, the formal dispute resolution mechanisms, the parties essentially have to subject themselves to the procedures that are laid down, for instance, by the court. They cannot change the rules of procedure of the court. They cannot choose the judge who is going to determine the dispute for them. So essentially the parties are ceding control over the way in which the proceedings are going to be conducted. At the beginning of the video, I suggested that there are a number of dispute resolution mechanisms, and we can place these various dispute resolution mechanisms on this continuum. Let's start by looking at where negotiation, for instance, takes its position on the continuum. Negotiation is where the parties to the dispute sit at the table together and decide how they're going to resolve the issues, the problems that have arisen between them. It's just the two of them around the table. Negotiation we find right at the left hand of the continuum, both on the consensual, adjudicative spectrum as well as the informal, formal spectrum. Negotiation is on the left, essentially because it's based on the parties' voluntary participation, it's consensual, they determine the outcome of their negotiations and the way in which the dispute is going to be resolved. It's also informal in the sense that there are no procedures, no formal procedures that determine how the negotiations are going to take place. This is left for the parties to agree upon themselves. So it's placed very clearly at the left hand of the spectrum. What we find with negotiation, though, is that parties can move into positional bargaining in the sense that they get entrenched in their positions, both feel that they are right in the way in which they are approaching the dispute, and the other party is wrong. Without a third person in there to try to break the tension, break the negotiation, facilitate it, it might end up that negotiation is unsuccessful. So this is where mediation comes in. As we've already indicated, the mediator is a neutral third party who is there to facilitate the communication between the parties. We see that mediation still remains on the left-hand side of the spectrum. This has to do with the fact that it's consensual by nature. We referred to the core element of voluntariness, so we have the voluntary participation of the parties. It's also consensual in nature that it's the parties who take responsibility for the outcome of the dispute. So they do not cede control to a neutral third party to determine how their problems are going to be resolved. When we look at the spectrum below on the informal versus the formal proceedings, we see that mediation remains on the left-hand side of the spectrum because it is an informal dispute resolution mechanism. The parties determine what proceedings, how they are going to run the proceedings, what the process is going to be, what the role of the mediator is, as opposed to giving over control to a neutral third party. When the parties are unable to resolve their dispute through mediation, perhaps even with the assistance of a mediator, the dispute resolution mechanism might take a step further to the right. It might be necessary to then hand over control of deciding the dispute to a neutral third party. And this is where the adjudicatory proceedings come in. And we're talking here about arbitration and litigation. Both arbitration and litigation, we'll find them on the right-hand side of the spectrum. If we look at the top spectrum of consensual versus adjudicative dispute resolution mechanisms, arbitration and litigation are both adjudicative, in the sense that a neutral third party forum determines the outcome of the dispute. The difference between arbitration and litigation is perhaps more to be seen on the lower spectrum when it comes to informal versus formal proceedings. Formal proceedings, there is, if we look right towards the right-hand side of the continuum to litigation, we see that that is the most formal of the proceedings. That is because if a dispute comes before the court, the parties are subject to the procedural law of the court that has jurisdiction. The parties also have no possibility to choose the judge who is going to determine their dispute. Arbitration is just slightly left to litigation because there the parties do have some freedom to determine which arbitration proceedings they're going to follow, who the arbitrators are going to be, so they have some control over who's ultimately going to decide the dispute. But it remains adjudicative in the sense that once they've decided who the arbitrator is, it's that arbitrator or the arbitral tribunal who will decide the outcome of the dispute. Another difference that we can see between dispute resolution mechanisms on the left-hand side versus the right-hand side of the spectrum is the way in which the dispute is resolved. If we look at mediation, we see that there is a focus on problem solving, resolving the problems between the parties that underlie the dispute. And in essence, that means it gives the parties the possibility to look forward, to repair their relationship, to mend fences, and to create a beneficial solution for both parties leading into the future. In essence, the goal of mediation is to develop mutual gain, a win-win solution. In contrast, adjudicative proceedings are based on the law. It is determining a dispute on the basis of legal norms. The parties or the result of the dispute resolution or the outcome of adjudication is not so much based on looking forward to protecting the parties' relationship in the future and is re-establishing it or helping them to continue their business relationship or their personal relationship with each other. Instead, adjudication is about things that have happened in the past. In this sense, you could say adjudication is backward-looking. It looks at events that have taken place in the past and applies the legal norms, the legal rights, the rules that are applicable to that event in the past. Litigation, arbitration is not so much concerned with the present or resolving a dispute that will allow the parties to work together in the future. Litigation, arbitration, so these adjudicatory proceedings are therefore essentially win-lose solutions to disputes. At the end of the day, when the arbitral tribunal or the court comes with a decision, one party is going to be the winner and the other party is going to be the loser. This could have an impact also on compliance rates. So when we have win-win solutions, for instance, coming out of mediation, the likelihood that the parties are going to be satisfied with the outcome and therefore comply with it is much higher than when we're dealing with adjudication. Adjudicatory proceedings lead to there being a losing party, and adjudication is antagonizing, it can be antagonistic, and once you come out of adjudication and you have the decision against you, your willingness, your satisfaction with it might be less, and your willingness therefore to comply with it lower. Another aspect of this continuum is that the left-hand side of the continuum, so mediation, negotiation, are likely to have lower costs, and also lead to quicker resolution of the problems between the parties. On the right-hand side of the continuum, arbitration, litigation, these are much more costly dispute resolution mechanisms. It involves a lot more lawyers. There are a lot more procedural elements to it that brings expenses with it. And at the same time, it can take a lot of time to get through the whole proceedings. So to sum up what we've been talking about in the context of this video, what mediation is in contrast to other methods of resolving disputes, I think one of the main things that comes out of the continuum that we were just looking at is that mediation is essentially a problem-solving mechanism. And this stands in contrast to the adjudicatory mechanisms, which are essentially about resolving the legal issues in a dispute. Where legal issues dominate, the nature of the arguments that the parties are going to make, the nature of their thinking is going to be different, and also the way in which they interact with each other. where mediations, or the strength of mediation, is, I think, that it is a problem-solving mechanism. So although a dispute might arise on the basis of legal issues, mediation aims to look behind those legal issues to resolve the problems that underlie it, so that parties can once again work together or interact with each other in a way that leads to a positive relationship in the future. One way perhaps of summing up what mediation is all about is to look at a quote that comes from Professor Lon Fuller, who wrote a seminal article on mediation. And he referred to mediation's capacity to, and I quote, reorient the parties towards each other, not by imposing rules on them, but by helping them to achieve a new and shared perception of their relationship. A perception that will direct their attitudes and dispositions towards one another. End of quote. So what we see is that mediation is not about the legal rights and the legal rules, but is about solving the problems. And when you're engaged in mediation, therefore, it requires you to make a whole different skill set your own.